The common elements associated with the living trust as a part of an estate plan, we want to remember this, that the trust avoids probate. Now, sometimes people will ask, well, how is that possible? Well, quite simply because that's the way the laws have been written at the state level and the federal level. When we create a trust and place our assets in that trust name, we're telling the probate system that we no longer need their assistance. We have someone in our family, perhaps, maybe a friend of ours, maybe a corporate entity, who's going to settle our estate for us, and we don't need the probate court to be involved. And they say, okay, we will stay hands off. People will occasionally ask me, well, why can't I go in my will and say I don't want probate to happen? Well, that's like trying to go outside on the street beside your house tonight and spray paint a new speed limit sign. You can't arbitrarily change those rules. We just need to remember that trusts are designed to avoid probate. Wills are not designed to avoid probate. Because of the trust avoiding probate, it's oftentimes then less expensive for your heirs. Well, why would that be? Well, remember the $16,000 to $60,000 that probate could have cost us? Whatever that number was, whether it's higher or lower, whatever that number would be, if you don't go through probate, you just saved that money for your family, for the people and places that you care about. Also, it eliminates the lengthy delays. The 9 months to 2 years can happen much quicker, can happen in just a matter of a few months' time, depending on how fast your family wants to go through this process. Now, they can stretch it out longer if they need to or want to, but they're certainly not waiting on the probate court to give approval to take the steps that need to be taken. Also preserves your privacy. The trust documents do not get processed or recorded by the probate court. Therefore, they never become a public record. So your next door neighbors, your coworkers, your extended family, none of them can go down and find out what happened to your estate by trying to look through your trust documents because they're not there. The only people that would have access to that information would be the person or people settling your estate for you, and the people that are your beneficiaries should be kept up to date on that process. And some states are now beginning to mandate that when you pass away, that your trust documents, a copy of them, are provided to the beneficiaries so they clearly know what's supposed to be happening. Also, remember the revocable living trust that we're talking about is completely flexible. It's the one we can change at any time. We can cancel it. We can put assets into that trust, take assets out of that trust, as however we may want to. Also, having the trust documents allows us to avoid the problems of joint ownership. Now, to think about joint ownership, I just want to go back and have a real quick history lesson. Back in the latter part of the 1940s, if a husband and wife bought a house together and one of them passed away, in order for the surviving spouse to put that property into their name, that property had to go through the probate process. So people began to complain all across the country, at the county level, the state level. And so this concept that we now call joint ownership was created. What joint ownership means is, for example, when my wife and I bought our first house together, our property deed said David and Deanna Hess, joint owners with the right of survivorship, which meant if one of us passed away, the surviving spouse could take that deed down to a local title company or a local attorney that did real estate and could get that deed changed into their name, and it would avoid going through the probate process. So that was a very good thing to do. It helped families save a lot of time and save a lot of money. Through the 1950s and 60s, people began to ask, well, why does it have to be a spouse? Why can't it be somebody else? So the rules of joint ownership have been expanded later on to the 50s and 60s and up to now, where you can basically own assets in joint ownership with virtually anyone. So if I was there with you, we could go downtown and buy a car together. We could open a bank account. We can buy a house, a piece of real estate. We can do all of those things as joint owners so that if one of us passed away, that asset can be transferred to the surviving person and doesn't have to go through probate. So that was a great thing to do, again, to help families save time and save money. Well, what we find is happening in today's world is that our senior adults are beginning to get really smart about these concepts. And so we have seniors that are going down and beginning to put their adult children's names on their real estate, on their property deeds, and on their bank accounts in particular. The idea being now, when that senior adult passes away, that real estate will transfer to that son or daughter and no probate's required. They're like, found a way to get around the government and save some money for my family. So we find that senior adults are doing that across the country now. Well, let's look at that same scenario here in today's world. Let's say my wife and I get up in years, I pass away first, and my wife decides to go down and put our adult son's name on the property deed with her as a joint owner. So when she dies, the real estate transfers to him, no probate. Well, my son is married and he has 5 children, and the oldest one has a driver's license. And so one night that young man is out driving the family car. He's in a car accident. Maybe it's his fault, maybe it's not. Maybe somebody's severely injured in that car accident. Here in today's world of 2023, what do you think is likely to happen to my son's family when that car accident occurs? Well, if you guessed lawsuit, you're probably right. So now, guess what my son owns when he gets sued? the property that my wife lives in because his name is on the deed as a joint owner. That property could become a part of that litigation. If my son lost his job and had to file bankruptcy, that property could become a part of that litigation. If my son went through a nasty divorce, that property could become a part of that litigation. Or if my son wanted to go downtown to buy a new vehicle, he could use that property as equity for that loan and not even need to tell my wife he's done that because he owns the property as much as she does. So you can see how joint ownership has some problems that can come along with it today that didn't exist when that concept was first created. How does a revocable living trust fix that? Well, if you looked at our property deed today for my wife and I, it no longer says David and Deanna Hess joint owners. Our property deed now says the Hess Family Living Trust, David and Deanna Hess trustees. We've changed our real estate, our bank accounts, our vehicle titles, other assets that we own into our trust name, and allows those assets to avoid probate. And now when the first spouse dies, the surviving spouse doesn't have to go down and change that real estate into their name because they still own and control the trust. So they leave it just as it is. Well, that alone saved us $300 or $400 in changing a property deed. Now, when the second spouse dies, if we want the real estate to be given to any of our kids, it can. Or if we want it liquidated and the money given to our kids, it can. And guess what? It still avoids going through the probate process. So I can use a revocable living trust to avoid any of those problems that would come along with joint ownership with somebody outside of me and my spouse. Also, I want you to know that having the revocable living trust and the tools that go along with it allow us to avoid court-imposed guardianship for minors. So we want to think about this issue for those of you that may have minor kids. So let me toss up the third poll question of the evening. So real quick, just tell us, those of you that are with us, how many of you might have minor children still? Any kids under the age of 18 at home with you? Just a real quick yes or no. This just gives us a great idea of what our audience looks like and who might be thinking about this issue. Now, even those of you that might not have minors, you might still be grandparents. You might want to have those conversations with your own children. You know, have they sorted out guardianship? Because in the unlikely event that something would happen to the parents or the guardians, whether they're adopted kids or whoever it may be, the court is going to appoint guardians for those children. And so we want to make sure that those children are protected. So it looks like about a little over 20% of you still have minors. So this is certainly something you want to think about. And again, those of you that may have grandkids, maybe you want to have that conversation with your own children. You know, it's very important to think about because even though it might not ever happen to you, it's not necessarily very likely. It's best to have your kids protected and make sure that you've had the chance to tell the court who you would like them to use. The court is going to manage and oversee that entire process, but it's best that you don't just leave them in a vacuum without any kind of information from you. Next, we want to think about naming our own healthcare agent. So along with the trust documents and things you would get, you're able to create a medical document. And this is going to be a medical document very similar to maybe what some of you might already have. So a few of you here might have what's called a living will. Now, a living will is a very basic healthcare tool that simply says, if I'm incapacitated for some reason, I'm in an accident or a medical emergency, and I can't communicate for myself, do I want you to take all measures possible to keep me alive? Or do I have that DNR, the do not resuscitate order that simply says, let me go, I'm ready to go and be at home with the Lord? That's what a living will is all about. It's a very basic healthcare tool. Some of you might have gone a little further than that and created a medical power of attorney. Now, a medical power of attorney is a document that can be created that would say, here are some things I might be okay with you doing for me medically, and here are some things I'm not okay with you doing for me medically, and here are some people that can legally make medical decisions for me if I'm unable to communicate for myself. In some states, that living will and that medical power of attorney have been combined into one tool known as an advanced healthcare directive. Sometimes that person's called your medical proxy, depending upon where you live. So having a healthcare document like that as a part of your estate plan is very important in today's world. You really can't go to the doctors for any kind of medical procedure where they're not going to ask you to at least have a living will. But you can go beyond that and make some advanced decisions to help your family. Also, having the trust allows for the quick distribution of assets. Now, I want to take a second here and just share with you a bit of my personal story and why I do what I do with FPM now. I told you after I spent 22 years in the Air Force, my wife and I decided to move back here home to Cincinnati. And so about 2002, I was serving on a church staff here on the east side of town. About that time frame, somebody from financial planning ministry, who I didn't really know, I didn't know much about them, on a Saturday morning, they came to our church and shared all of this information that you're listening to this evening. Now, my wife and I, we had a couple of these documents in place at that time, but not all of them. So we decided, let's get all this done and let's get all of it put in place. So we did that. A couple of years later, my mom and dad went through the same process and got all of their documents completed by FPM. My father passed away in 2009. My mom passed away on December 4th of 2012. Now, why do I tell you that date? Because by the end of January 2013, less than 60 days after my mom had passed away, we had sold their car, sold their house, paid the few debts they had left all the charitable gifts they wanted to leave, and made all the distribution to the family. All of that was done in less than 60 days. None of it had to go through the probate process. We didn't have to hire an attorney to help us do anything because my parents' documents gave us all the powers and authorities and instructions that we needed to make everything happen. And we had a legal obligation to follow those instructions. We could not change them. You know, my brother and sister and I, we didn't have to go into our parents' house and have any discussions or worse yet, fights and feuds over where all this stuff goes. You can make all of those decisions in advance. What happens to the furniture? What happens to the jewelry? Where does the car go? All of those kinds of things can be sorted out by you in advance, which makes it much easier on your family. You know, part of being a good steward is having a plan in place that provides for your family, protects them, and also allows you to do some things within the kingdom. So I hope you'll take this away. If you don't take anything else away from what I'm saying tonight, please remember this one thing. All of these things we're talking about doing is not for your personal benefit. It's to benefit the people who come after us who have to take care of all this. You know, I'll be in heaven singing David Crowder songs or Chris Tomlin or hymns or whatever we're singing. I don't know what we'll be doing, but I won't be worried about the furniture in the house or the car in the driveway. Somebody else will be doing that. Could be my wife, could be my kids, my grandkids. And I want to make that process on them as easy as possible. That's why we think about having this estate plan in place. Now, I also want you to know, depending upon your situation, if you're a married couple, that an A-B marital trust could reduce or eliminate federal estate taxes, okay? An A-B marital trust could reduce or eliminate federal estate taxes. Now, every year, about December timeframe, the government decides what is the federal estate tax threshold going to be. So what size estate will be subject to that will change every December, and then it goes into effect in January. So you have this chart that's in your outline, if you have that, and you see at the bottom there where it says current year. The current number is $12,920,000. What that means is if a spouse died and then the second spouse dies here in 2023, if their estate combined value is less than $12,920,000, then there's no federal estate tax. But if their estate is over that number, then the federal government wants 40% of the difference. So let's say that we had a family that has a small business or a family farm. Maybe they have a dozen employees. And so if they passed away, everything they owned got liquidated would be $15 million. So the difference between 15 million and roughly 13 million is about $2 million times 40% would be $800,000 that family would owe in federal estate taxes. Now, if before either one of the husband or wife passed away, if they create what's called an A-B trust, now the government lets them double that exemption from $12,920,000 to $25,840,000 before that federal estate tax kicks in. So you're thinking, well, why wouldn't we all run out and just create an A-B trust so we're protected as much as we could be? Well, because here's how that process works. When a husband and wife create an A-B trust and the first one of them dies, they must by law split the estate into two equal pieces, 50-50, an A side and a B side. The surviving spouse can do whatever they want to with the B side, but they can't take the A side principal. They can go over here and grab the interest and pull it over and use it, but that A side has to stay there. Now, when the second spouse dies, the two pieces can come together to go back to their beneficiaries. And if their estate is below the $25,840,000 number, then there's no federal estate taxes. So you can see that an A-B trust could be beneficial if some family had a very large estate. If they were over the $12,920,000 number, certainly an A-B trust could be something to talk about. And we'd be glad to have that conversation with you. Now, you can go back in time and see that the number was much lower before in the late 90s and early 2000s. Will it go back to that? We don't know. We watch and see what the Congress does each and every year. Sometimes they fight about it. Sometimes they make a basic decision. It's pretty easy, but we just watch and see where this goes from year to year. Now, I want to explain how a living trust works, and I want to use the example of a treasure chest. So hopefully you can read that. It says R.E. Perkins, Honolulu. Now, R.E. Perkins was nobody famous. This was my mom's brother. His name was Robert, and we called him Uncle Bobby. My Uncle Bobby was a fighter pilot in the Air Force in the 1940s, 50s, and 60s. He traveled all around the world as a fighter pilot and a demonstration pilot. He bought this trunk in Honolulu, Hawaii, and when he passed away in the late 60s, he left this to my mom and dad. And it used to sit at the foot of their bed and it had a padlock on it. And when I was a little kid, I used to walk by that thing and think, man, that thing's got to be full of treasure. I can just imagine what was inside of there from all the stuff he had collected traveling around the world. Well, as my folks put together their estate plan, they asked my brother and sister and I, what are the things out of the house that you kids want when we're gone? And I said, I was in the Air Force like Uncle Bobby. I had that kindred spirit with him. I'd kind of like to have that treasure chest, secretly thinking maybe I'll get everything inside of it as well. Well, I told you my father passed away in 2009. Well, when that happened, we needed to go through all the stuff that our mom had and make sure that she was going to be able to be taken care of. So one night, my brother and sister and I, we got together, we had dinner with our spouses, and we opened up that treasure chest that you saw. And I want you to know that it was full of treasure, but not the kind of treasure that I thought of when I was 6 years old. The things that we found inside were some pieces of jewelry that belonged to our grandmothers, nothing really expensive. We found an old Ziploc bag that had 5 or 6 old Timex watches in it that we'd given our dad for Father's Day or his birthday. The stem had fallen out in 3 or 4 months and it quit working. He never threw them away because they were just sentimental to him. My dad and several of his older brothers had fought in the Army in World War II. They all fought overseas in Germany. And one of my uncles was a German POW for the last 9 months of the war. And when the war was over, he was released, came back to the States, and he was awarded the Bronze Star and some other military decorations. There were photographs of him and his family when he received those medals, and his actual Bronze Star, still in its original case, was in that treasure chest from the end of World War II. We had another family member on the USS Nevada in Pearl Harbor. He had been killed on December 7th, and some of his effects had been found and sent back to the family. They were inside the treasure chest when we opened it up. But the thing that made our wives cry the most that night when we went through all that stuff was that when my father passed away, my parents had been married for almost 60 years. And when my dad wanted to ask my mom to marry him, he went to this little jewelry store here in Cincinnati to buy her engagement ring. Well, he didn't have enough money to pay for it. So they told him, you come in every payday, which back then was every Friday. He'd go in every Friday and pay $5 a week on that ring until he paid it off and could bring it home and get engaged. That little payment book from nearly 60 years before was still inside the treasure chest. And all of our wives got all teary-eyed and weepy-eyed. Now, that's a sappy story, I know. But the reason I tell this story is this. If you decide that you want to create a trust as a part of your estate plan, I want you to think of your trust as your treasure chest. The way that you protect the assets that have value to you, whether you're talking about financial value or intrinsic value, whether you're talking about protecting your family from these processes, if they're inside the treasure chest, they'll be protected. If they're outside of the treasure chest, they're not protected. So let's go through these final steps and then see what questions you might have. So in creating the trust, the first thing you would do is you would name yourself as the trustee. Now, as I told you, my wife and I, we have a joint trust. We are trustees together of our trust. But if you were single, you could be the trustee alone of your trust. You're the only person that can put things in and out of that trust or make changes to that trust while you're alive. At some point in time, my wife and I will be gone. We're going to be passed away. And now we need a successor trustee. So we're going to name this person who's going to serve kind of like an executor of our estate, but they're not restricted by time because they're not following the probate court's instructions. They're going to use your documents and carry out all the things that need to be done without that supervision of the probate court. So this should be somebody certainly that you trust to do this. It's a good idea to sit down and have some conversations with them. Make sure they understand what you're asking them to do, what you need them to do. This could be anybody who's an adult, could be one of your siblings, could be an extended family, could be one of your adult children. Typically, a good idea to name a primary and then an alternate or two. So if for some reason the first person can't do it, it goes to the second or third. Occasionally, someone might want to think about having a corporate trustee. Perhaps they want to use a bank or a financial institution they're connected to. Those banks or financial institutions would charge you a fee to serve as your corporate trustee. So make sure you find out from them what that cost would be for you. Then you're going to name that healthcare agent for you. That's that person who's going to make those medical decisions if you're incapacitated. And now, if you're married, your spouse is probably your first choice, but then it's a good idea to have an alternate as well as a healthcare agent. Then you're going to name a guardian if you have minor children. Who do you want the court to appoint or consider appointing as your guardians for your kids? And then you're going to name the persons and the charities that you want to receive your estate. Just like I did in my will. So if I only had a will, my will would have said, when I die, everything goes to my wife. But if my wife's not there, now what happens to it? Well, part of it goes to my kids, my gifts to my grandkids, gifts to charities, and gifts to my church. All those are outlined inside my will. Now, when I created my trust, I did the same thing. My trust says if I pass away, my wife controls and owns everything. If she passes away first, I own and control everything. But once we're both gone, now the trust through that treasure chest says, do what with it? Give it to my kids, my grandkids, my church, and my charities. I have it all broken up in percentages. Now, also inside your documents, you can also say, maybe I have minor children that I don't want them to receive everything right at the age of 18. Maybe I want them to get part of it for education first, and then they can get part of it at 21 or 23 or 25. I can kind of spread that out over a number of years for them. Then I'm going to retitle the assets that I own by the name of my living trust with myself as the trustee. So, for example, I told you my wife and I, we changed our property deed into our trust name. We've changed other assets that we own into our trust name. So that would be things like the deed to the house, the real estate that we own. Even if you have an existing mortgage on your property, you're not changing the mortgage document. You leave it alone, but there's another document that was created by the title company called the ownership deed. That's the document that gets changed into your trust name to protect it from probate. Should you decide to sell your property in the future, you don't have to take it out of the trust name. You would simply sign your name and your trust name at the closing. Savings and investments that you have, bank accounts, stocks, bonds, mutual funds, all of those kinds of assets can be transferred directly into your trust name. Other titleable assets that you own. So if you own your car, own a boat, own a camper, own a motorcycle, you can change those titles into your trust name. The goal is to make sure that none of these assets ever get under the control of the probate court. Then you're going to have some other assets like an IRA or a 401k or life insurance, where you're going to add the living trust as a secondary or contingent beneficiary. So if you looked at my life insurance policy, you would see that my wife is the first beneficiary, but then if she's not there, it says the secondary beneficiary is the Hess Family Living Trust. So those assets would then pay into the trust, and my trust says do what with them? Give them to my kids, my grandkids, my church, and my charities. Makes it a very simple process. Now, let's go through the top 10 questions that are there in your note-taking outline. And then if I haven't answered your questions, we're going to take some from you here in a second and get this all wrapped up here in just a few minutes. Number one, is the living trust a new idea? No, it's not. Trust has been around since the time of the Romans. We've had trust documents, all kinds of legal documents here in the United States since the 16 and 1700s. So English law, as all that was coming here, that became the basis for what we use here in the United States for the vast majority. I think the misconception that's there is that unless you have that $12 million number to worry about federal estate taxes, then a revocable living trust doesn't really help you. Well, that's not true. If you want to avoid the probate process and save the expense for your family, whether that's $16,000 or $60,000 or more or less than that, you can save all of those funds by using the trust process. We don't have to be multimillionaires. Number two, does the transfer process of my property into the trust affect my property taxes? No, it does not, because I didn't sell the property. The county doesn't come out and reassess your property. They don't change your tax rate. If you might have some kind of exemption, like a homestead exemption, the county would simply ask you to fill out another form and they re-grant that homestead exemption.
Lucy needs to hear this.
Number three, may I include the distribution of personal items in my trust? Certainly you can. Perhaps you've got a piece of antique furniture, a collectible, a piece of jewelry, something sentimental, and you want to pass on that item to some specific family member. There's a page inside your trust documents that you can update whenever you want to, listing those items and who's supposed to receive them, so your trustee knows to give those items to those people. Number four, is it necessary for financial planning ministry to know the total value of your estate? Well, the short answer is yes, if you're going to ask us to help you. Now, what kind of information do we need? Well, we don't want or need account numbers, and we're not going to ask you to give us social security numbers. We want to know things like, I have a Chase checking account with $500 in it. I have a Chase savings account with $5,000 in it. I might have a Prudential life insurance policy for $100,000. I have a Fidelity IRA that's got $15,000 in it. And I have a piece of real estate at this address that's worth $200,000. Those are the kinds of details that we want you to tell us about. Now, those names and those numbers are not going to appear in your documents. Well, then, Dave, why would you want them? Two purposes. First of all, we're going to create for you a roadmap, set of instructions that we're going to give back to you when you get your documents from us. It's going to say, okay, now you need to go back to Chase Bank and you need to do this. You need to go back to Prudential and you need to do this. You need to go back to Fidelity and take these steps. So we give you details about how to make sure you're going to properly connect your assets to the trust name, and that's why that information is helpful to us. Also, knowing those numbers lets us know that we are creating the right kinds of documents for you. Sometimes people might be near the federal estate tax threshold, or they might live in a state where there's an inheritance tax, or there is a state level estate tax. So depending upon who they're leaving gifts to and how they're setting up charities, those things can certainly impact all of those issues. And we just want to have those kinds of conversations with you. Now, I want you to know that all the information you provide to us through this process, if you're working with us, is confidential between you and between us at FPM. We don't give your information to anyone. We don't sell it to anyone. We're never going to call you and try to get you to buy insurance or move investments around. We don't do those kinds of things. We don't sell products. We're not going to give your financial information back to the church there at Willow Creek. So I'm not going to call up Matt and say, hey, Matt, when you're ready to remodel over there at the South Barrington campus, make sure you call the Smith family because they can really help you out. They don't see that information about you. Number 5, can I make changes to the trust after it's notarized? Certainly you can. 5 years, 7 years down the road, whenever it may be, if you need to make changes to who's a trustee, who's a healthcare agent, who's a guardian, who's a beneficiary, anything like that, if we created your documents, contact us. We'll be glad to make those amendments, changes, updates that you need. We do that for the lifetime of your documents with us, and we don't ever charge you for any of those services. Number 6, does a living trust make sense for a single person? Well, certainly it can. A single person can own all the same things that a married person can, and that single person is probably closer to needing to designate that healthcare agent that we're talking about. And if you got married in the future, you could always update your documents. Number 7, is a living trust practical for a smaller estate? Well, I don't know what you consider small, but let's say $50,000. If you probated $50,000 at 7%, that could cost $3,500. Most of you would not waste $3,500 on a process if you could avoid that and use those funds for your family or places that you cared about. Number 8, does a living trust avoid probate on out-of-state property? Certainly it can. So you live there in Illinois, but maybe you've got a piece of real estate in Florida or Texas or somewhere else here in the U.S. Every place you own real estate in the United States, you could potentially have probate upon your passing. So if you change those properties that you own into your trust name, even though you live in Illinois, you can avoid your family going through probate in all of those out-of-state counties as well. Number 9, does the living trust restrict my rights to my property? No, not in any way, shape, or form. My wife and I can give that property away. We can take it out of the trust, sell it, whatever we want to do, whenever we may want to do that. Number 10, if I'd like to establish an estate plan, what is my next step? Well, let me ask you the last poll question of the evening. Those of you with us here still, how many of you already have current documents? Do you have a will that's current? Do you have a trust that's current? Maybe you don't have any current documents at all. Maybe you don't have any documents whatsoever. So just real quick, respond to us. Let us know. This just kind of gives us an idea of how many people might be thinking about needing some kind of assistance. Maybe you have some documents that you still need to get updated and changed. Maybe some of you, again, don't have anything at all, or you know what you have is no good. It's just so old. It just really needs to be updated. So I'll give you a couple seconds there if anybody else wants to jump in and respond. We just want to kind of get a feel for where people might be. Now, remember I told you earlier that about 65% of the adults in our country don't have any kind of estate plan. So those of you that are here with us tonight, this is what you shared with us. 79% of you said you do not have current documents. Wow. So you're not alone. What do? What are your options? What kind of things are available to you? Well, you could go out and get some software. You can go down to the Best Buy store, go down to Office Max, buy some software and print some things out there. You can go online. You can go to LegalZoom.com. You can go to other services. There's been several things pop up since COVID happened where you can go online and print out your own documents at home and get them signed and notarized. Those tools aren't incredibly expensive, maybe $75 to a couple $100. Sometimes somebody wants something done in a hurry. Before COVID happened, I would be called many times on a Wednesday, Thursday. Somebody would say, hey, Dave, we're going on a cruise this weekend. Any chance we can get some documents done in the next couple of days? Well, not typically by us. We have a little lengthier process than that to go through to make sure things are done the right way. But sometimes somebody's just looking to get something done in a hurry, and that's an option that you have. You could go out and contact some local professionals. We're not here to talk you out of trying to work with local attorneys. That's not our goal at all. Our goal tonight was to educate you on this process. Now, we would encourage you to find someone who's an estate planning attorney, which about 10% of all attorneys work in that field specifically. So find somebody who's going to specialize in what you're trying to do. The documents we're talking about creating, the wills, the trusts, powers of attorney, healthcare documents, including guardianship, maybe property deeds we have to create. All of those tools would typically cost you with a local attorney somewhere between $1,500 and $4,000 for a married couple. Now, the bigger the city, the bigger the price tag, the more extensive your plan is, the more that would cost. That's an option there. Also, Financial Planning Ministry belongs to an organization called the Christian Legal Society. So we are connected with Christian attorneys all over the country. We could go into that database. If you called us and gave us your zip code, we could tell you, here are some attorneys around you that might be able to help you. You contact them, vet them, see if you want to pay them to do the work that they would provide for you. We're glad to do that as well. You could work with us at Financial Planning Ministry should you choose to do that. And if you decide to work with us, we don't ever charge you for any of our services. And as I explained earlier, that's because our ministry is funded by our 150 plus ministry partners, such as Willow Creek. So perhaps when you create your estate plan, you've decided, hey, you know what? I want to leave a gift out of my estate plan to my church here at Willow. Maybe there are other charities you have connections with that you want to leave gifts to. We would certainly encourage you to prayerfully think about doing such a thing. Because we don't charge for our services, we want you to think about doing something charitable in return. So that's how our process is able to help you. Now, if you think that sounds like something that you want to do, if not, you've always got other ways to do some things there to put your documents together. But if you would like us to help you, let's talk a little bit about how that works from the 20,000 foot view. So we would schedule an appointment with you, and I'll explain how that appointment is going to work here in a second. You would complete our online digital planning guide. We send a link to you so that you can fill out this planning guide online. Again, you're not putting account numbers in there. You're not putting in social security numbers, so you're not worried about somebody stealing your information. After you complete your planning guide and turn it in, then you're going to have a phone consultation with one of our team members to review your planning guide and go through your information, answer any questions you have, answer questions that we might have to make sure we have everything sorted out for you properly. Then we're going to create your documents. Those are going to be mailed to you in about 45 to 60 days. You're going to get your will, your trust, your healthcare document, guardianship, property deeds, whatever those tools are we're creating for you. You decide what you need us to create. We get those documents sent to you. Once you get them from us, we want you to review them again, make sure they're all accurate as far as names, addresses, phone numbers, and so forth, right people in the right positions. Get your documents signed, dated, notarized, all those things that need to be done. And then take those steps through the roadmap we give you to fund your trust. You're going to connect your assets to your trust name. You're going to put things in your treasure chest to protect them from probate. And then in the future, any updates, changes you might need, contact us. We'll gladly make those updates for you at no cost to you. Now, if you're interested in us helping you again, you're going to want to jot down that event code, Willow 2303. Now, we're going to be doing a bunch of appointments on April 10th, 11th, and 12th. We have several different consultants that are going to be meeting with folks on those days. We actually gave out this information Sunday to the two groups that were there. So some of them have gotten a little bit of a head start on you in picking out appointments. But you can go tonight and schedule your appointment. You can wait till after this is all done. We will send you an email. Probably sometime late tomorrow, you'll get that from us explaining how to schedule an appointment if you don't write all this information down this evening. So when we're done tonight with this event, you're going to be taken to this screen. This will pop up on your device. You could go in there and put in Willow 2303, 2303. It's a 0, not an O. And then you could schedule your appointment. You can pick from those dates and times on the 10th, 11th, and 12th. There's going to be appointments in the morning, some in the evening, some in the afternoon. They're about 45 minutes in length. We'll ask you to fill out that planning guide. So when you get your appointment scheduled, you're going to get an email from us that looks like this. This email is going to have a link to that digital planning guide. It's going to have a link to who is your consultant, the person that's going to be meeting with you. And it's going to have your event code listed there. Yours is going to say Willow 2303. Now, whoever's name is on this email, wherever that consultant name is, whoever that's going to be, that's important because when you go and click on the planning guide link, it's going to ask you, who is your consultant? So whoever's name is on that previous email, make sure you click on their picture so that your planning guide goes to them so that they can properly assist you through the process. They'll call you at the date and time that you've chosen. They'll have a copy of your planning guide. You'll have it, and they'll go through that with you and do that review. All right, so that's how you schedule an appointment with us, should you want to do that in the future. So if you have questions, I'm going to go through some of the Q&A that's here. You can always email me. There's my email address. If you don't want to wait and you want to schedule an appointment right now while we're on, you got your smartphone, you can aim it at that QR code. There's the event code that you would need. Also, our phone number to our office is there. Should you have questions after we're all done tonight, you can also reach out to our office. All right, so let's jump in here and see what kind of questions we have. All right, outline, semi-outline. Got a couple of those. Okay, outline. A bunch of people need outlines. I've got all that. Perfect. Outlines, let's see. More outlines. Lots of folks want outlines. All right, we'll get those to you. Let's see. Someone said, I have a trust that was written in Illinois, but now live in Wisconsin. I was told that I need to have a new trust document. Is that true? Well, it depends. That's a great question. There could be aspects of your documents because you probably have a trust. You probably have a will that was with that trust. That will might need to be redone because sometimes wills are specific depending upon where you move from and to. If you had a healthcare document that was created in Illinois and now you live in Wisconsin, you would want to update that healthcare document as well. So we would be able to look at your trust documents that you already had created, and we can help you make amendments, changes to those to get those accurate for where you're at. So there might be changes need to be made to those, might not. It just depends on what the documents say. So we would certainly want to look at those and decide how we could best help you. Is there property or assets that should not be included in a trust? Well, remember when we talked about the kinds of assets that you connect to your trust name. So things like cars, boats, your house, those things can be put directly into a trust. But you might have assets like an IRA. An IRA does not go in a trust. You can use the trust name as a secondary beneficiary. So every asset that you own in one way or another can be connected to the trust, either by naming it into the trust or using the trust as a beneficiary. So there's really nothing that you need to exclude from the trust unless you had some asset that you wanted to go to somebody else that you weren't naming as a part of your trust process. You can always leave somebody as a beneficiary on like a life insurance policy, and it goes directly to them. Again, that just depends on what you're going to do. When you fill out the planning guide, you list all of your assets, but then you will determine when you get your documents which of those assets you're going to connect to the trust and which ones you're not going to. All right, let's see. Thank you for your positive comments. I appreciate that. Someone said, I'm married. Can I put a different person as a guardian for my minor children, or will they go to my husband by default? Well, remember, if the biological parents are alive, then there are parental rights that exist unless the court has voided those parental rights for some reason. So if you're in the process of being separated or divorced, and you know that that's pending and there could be some custody issues, you could always name the person that you want to become the guardian for the children, but the court is always going to make those decisions based on what they feel is in the best interest of those children. So it's always best to put down your wishes, and then the court will determine those things, but you want to tell them this is what you want to have happen. All right, someone else said, I live in another state other than Illinois. Can you help me? We help people in all 50 states across the country. So regardless of where you might live in the US, we are glad to assist you. I'm always asking if anybody lives in Hawaii wants me to make a visit to them, but I can't ever get anybody to do that. So, all right, see some more outline questions. I'll get those to you. Does a trust protect your home or assets from seizure by Medicaid if you have to move into a nursing home? So a revocable living trust is not a tool designed to protect against the Medicaid look back. It's a probate avoidance tool. If someone is considering issues like that of nursing home care, then we might suggest they try to find an elder care attorney to help them create the right kind of documents for that, which could involve the creation of an irrevocable trust, which FPM does not create. We only create those revocable kinds of trust. So if someone's concerned about assets in a nursing home and Medicaid, we would encourage you to find a local elder care attorney to help you with those issues, because they're going to want to do some very specific things. That's a great question, though. Can you explain more about the charitable donation option? Certainly. So because we don't charge you for our services, we simply ask people that we're assisting to consider being charitable in return to the organizations that made this possible for them. You decide if you're going to do that or not. We think most people will, because they understand the stewardship concept. They realize that we've saved them thousands of dollars through this process and probate. And so you might want to take a portion of that you saved and leave it to your church or other charities. We don't have a requirement of what you have to do, whether that's a dollar amount or percentage. That's totally up to you, your spouse, if you're married, and the good Lord to make those decisions. But we would certainly encourage you to be good stewards of what the Lord has blessed you with. All right, somebody said, I don't have anything other than a checking account at this time. Can I still create a trust to prepare ahead of time? Well, you can always create a trust anytime. If you're an adult, you can have trust documents. And then as you acquire assets, you can always connect them to the trust. So that's totally up to you. You decide that maybe you just want a will and a healthcare document now. We're happy to do that for you. We will make whatever kinds of documents you think you might need, but that would be a great conversation to have with one of our consultants during your appointment. Do we need to add assets outside of the country? Another great question. So U.S. law cannot control assets outside of the United States. You could make a list of them and put them with your trust documents so that your trustee is aware of them. But if you have assets in a foreign country, you're going to have documents created in that foreign country to determine where those assets would go. Some great questions here tonight. I really appreciate these. You guys are full of great questions. Let's see. The complete online planning guide is where we have to list our assets and our accounts. Yes, when you get that planning guide, that's where you would put in there, I have a checking account at this bank for $500. I own this real estate at this address. Those kinds of things will go in that planning guide. We use that to meet with you, and we use that information then to create your documents. All right, last one, and then we're going to wrap this up because I don't want to keep you on here too long. If my assets have beneficiaries or TOD assigned to them, is a trust still needed? So when you have assets that have a beneficiary, if you pass away, then that beneficiary is alive, that asset would go to them. If you have an asset that has a TOD, which is a transfer on death designation, if that person is alive, it would transfer to them. The problems with TODs is sometimes you can't name minors as a TOD. So some people have minor children and they can't use that process. And the second thing would be if that TOD person passed away before you and you forgot to change that, now that asset could go right back into probate. So sometimes it's easier to use the trust name and say, if this person isn't here, I want it to go here. If this person isn't here, I want it to go here. So you can name multiple layers of beneficiaries to the trust that you can't always do as a beneficiary on an instrument or as a TOD. But again, those things can avoid probate. They just might not necessarily always work well depending on what's happened there. When do you get the planning guide? Well, you get the planning guide when you schedule your appointment. So if you decide to meet with us, you schedule an appointment, there'll be a link in that email you get back that gives you access to that planning guide, and then you start filling that out. And then those appointments are about 2 to 3 weeks away, so you should have ample time to get the planning guide filled out before your appointment. All right, so I'm going to stop questions there. If you have other questions, please email them to me. I'll be happy to answer them. But for now, we're going to go ahead and ask Matt to come back on and join us. He's going to wrap us up tonight.
Thanks, Dave. As always, incredibly helpful. I hope you guys found it to be helpful as well. This guy really knows this stuff. FPM is a great organization, and we just really hope and pray that this, what you learned tonight, is a resource to you. And we just urge each one of you to take advantage of this opportunity and talk to Dave and his team and get some help in this area. And we think it's going to set you up well going into the future. So, Dave, thank you for your time as always. And yeah, everyone on the call, thanks for giving us some time tonight to listen and be here. Good to be with you all, albeit virtually. And hope you have a great night.
Thanks, Matt. Thanks, everybody, for joining us. Take care. God bless.